At State Trustees, we know that sorting out a loved one's affairs after their death is often a traumatic experience, and that's why we're here to help. We are one of Victoria's largest administrators of deceased estates with over 70 years' experience. Becoming the executor or administrator is a decision which should not be taken lightly. You are personally liable for the decisions you make. It is very time-consuming and can be very challenging if you lack the relevant knowledge in business, finance and law. An executor is the person or organisation that is responsible for managing all legal and financial issues that arise from a will. If there is no will, the court appoints an administrator to finalise the deceased's affairs. An administrator has the same responsibilities as an executor. There are 3 types of executors: sole executor, co-executor and substitute executor. As sole executor, you are the only person or entity appointed to manage the estate. Making decisions can be straightforward. However, you must do all the work, including paying outstanding bills, lodging tax returns, and ensuring all assets go to the correct people. You may also have to settle disputes between family members and perhaps even defend the estate against legal challenges. As co-executors, you and other people or entities make the decisions together. However, this will usually result in longer delays because you share the responsibility for finalising things. Substitute executors are basically the backup if the executor passes away before the deceased does, or they are unable or unwilling to take on this responsibility. Every estate and every will is different. There are practical things you'll need to do, such as identifying and securing assets and finding new homes for pets. It's also your role to apply to the court for a grant of representation, locate all the beneficiaries, and distribute or sell assets and lodge tax returns. Your workload will depend on the complexities of the situation. A simple scenario is called survivorship situation, where all assets are held jointly by, say, a husband and wife. In this case, all jointly held real estate, shares and bank accounts automatically become the property of the survivor or is left to one person, such as a spouse. Decision-making becomes more complicated when there is no survivorship situation and you need to manage the full estate. It can take up to 3 months to receive a grant of representation to allow you to deal with the assets in the estates, like transferring property or shares or accessing bank accounts. You may also have to cover funeral costs and other estate expenses out of your own pocket. No matter how simple a will seems, often things will go wrong. The will hasn't been properly signed or witnessed. Property titles have been lost. People make claims against the estate as domestic partners or dependents. There may also be issues with superannuation entitlements, insurance, or unexpected tax bills and credit card debt, all of which can cause delays for months, even years, and can be very costly to resolve. State Trustees has the skills and experience to help mitigate the impact of these sort of unexpected surprises and solve the issues as quickly as possible. If you've been nominated as executor or were thinking of being the administrator, it's ultimately up to you whether you accept the job or not. Many people find the responsibilities and the legal liability too much. Others just don't have the time. State Trustees can help. We need to be appointed prior to a grant of representation to become involved. Once appointed, we then take care of everything on your behalf. Our expertise in law, finance and tax means we can manage the estate with the best interests of the beneficiaries and your loved ones at heart. We'll make arrangements to sell or transfer assets such as real estate and belongings according to the wishes of your loved ones. Prepare tax returns for the deceased. Importantly, we'll work to resolve disputes and defend the estate against any legal challenges which often arise. Finalising estates can take more than a year. When all disputes are resolved and tax clearance is received, State trustees transfer all assets of the estate to the right beneficiaries as quickly as possible. When you choose state trustees, our experts take care of everything. You can be sure the estate will be managed professionally, independently and impartially. We are impartial. We don't get caught up in disputes between family members. And we have legal and financial experts to handle all claims and challenges to the estate. State trustees also provide long-term assistance with trusts and administer trusts for children or other dependents that could last for years. Most importantly, State Trustees offers peace of mind. We can help you take care of everything according to your loved one's wishes and in the best interests of their beneficiaries.